Thank you, Mr. Chair and members. Ross Brown with the Legislative Analyst's Office, and the committee has asked us to provide a little bit of background information on the PUC's recent zero-based budget exercise that is in response to a legislative requirement. So I will, you should have a handout that we put together in front of you, so I'll try and move through that fairly quickly. We'll skip page 1, has a little bit of just basic PUC background. Page 2, I probably don't need to go over a lot of this with you, but in recent years, there are several incidents and reviews that led to legislative concerns about PUC's operations. For example, a 2012 audit conducted by the Department of Finance identified significant weaknesses with PUC's budget operations. Some of the deficiencies identified were ineffective assignment of budget duties, insufficient staff training, and inadequate fund balance reconciliations. There have been a couple of other audits that I won't go through at this moment, but that's one of the major ones. In response to some of the concerns that were raised, the legislature approved trailer bill legislation in 2013, which included a requirement that PUC conduct a zero-based budget for all of its programs by January of 2015. Page 3 just goes over what is a zero-based budget, or ZBB. Generally, the term ZBB refers to a system of budgeting that requires an analytical justification for each program or activity proposed in the budget. Now, the term sort of analytical justification is key as I get to later on our review of the zero-based budget submitted by PUC. In practice, ZBBs have evolved over time and currently take many different forms. Some of the different forms and alternatives used by governments include what's oftentimes called a standard ZBB, which attempts to clarify a minimum level of funding needed to continue a program and then analyze trade-offs associated with funding levels above that. Another example is what's sometimes referred to as a periodic agency review, which oftentimes gets dropped into a ZBB category, which is a comprehensive review of an agency's mission, legal requirements, and whether the agency's allocation of resources reflects its mission and priorities. So if you turn to page 4, we give a brief description of the document that PUC and the report that PUC submitted in response to the requirement for ZBB. The report generally answers 3 basic questions, which is, what are PUC's legal requirements and responsibilities? What types of activities does the Commission conduct to fulfill its responsibilities? And how many resources, including staff and funding, are allocated to the different types of activities? And we do want to note that given the breadth of the responsibilities and activities within PUC, the information in the report can be helpful to the legislature to better understand what PUC does and how many resources it has devoted to some of its activities. If you turn to page 5, we really just address our basic finding based on our review of the zero-based budget submitted by PUC. And based on our understanding of the various types of zero-based budgets, the PUC report is not a ZBB. As I mentioned before, a common goal of most ZBBs is to encourage agencies to analyze their existing resources in an effort to determine whether resources could be deployed in a more efficient or cost-effective manner. And while the report includes a description of some of the resources that it has and some of the activities that PUC performs, it doesn't provide an analysis of those resources and the extent to which they're allocated efficiently or cost effectively. If you turn to page 6 of the handout, in light of that finding, we provide some issues for the legislature to consider as it moves forward. And the legislature will need to determine what, if any, additional analysis it wants in light of what's in and what is not in the zero-based budget. The legislature may want to consider some of the following issues when weighing its options moving forward. The first and perhaps most important one is we suggest the legislature be very clear about its goals and expectations of any future analysis that it wants of PUC's operations. The authorizing statute didn't include detail about the legislature's goals and expectations for the ZBB, and if going forward the legislature wants additional information or analysis, it'd be helpful to provide more specific guidance on its goals and expectations. For example, if the legislature is interested in information on more specific aspects, such as contracting practices, it may want to be more specific about those goals when requesting the analysis. Second, those goals and expectations should drive the additional direction to PUC. And if the legislature determines that it would like additional analysis or information, goals and expectations help inform what type of additional analysis or information it needs. For example, if the legislature is interested in an analysis of the degree to which PUC is following contracting practices or requirements, then a zero-based budget might not be the most effective tool for getting at that particular issue. And an audit of past contracting practices and the degree to which they comply with state statute and regulations might provide more useful information in that area. And I'll conclude my comments there, and I'm happy to answer any questions.
Thank you.
Yeah.
Mr. Chairman, members, Ed Howard with the Senior Counsel with the Center for Public Interest, Center for Public Interest Law, the University of San Diego School of Law. Thank you very much for allowing me the opportunity to address you. I've been asked to address how the issues raised in the background paper, a really excellent background paper, implicate the public interest. And I think in order to do that, I have to take a step back for a moment and take a look at the very big picture about the role of government when it comes to taxpayers and ratepayers. If I, as a taxpayer, don't like the way that the state government is managing a program paid with my tax dollars, I can't shop around. I can't go to another state of California with my tax dollars. I am forced to pay my tax dollars to the state no matter how well or how poorly it performs. And the same is true with ratepayers. With ratepayers, we have no choice but to pay our bills, regardless of whether the CPUC is a fair and competent steward of their money, whether they're doing a good or bad job. My point is this, that when the public is compelled to pay their hard-earned money, whether in the form of a rate or whether in the form of a tax bill, to state agencies like the CPUC, the laws of conduct for that state agency and the accountability that comes from doing the public's business in public, those things exist not only to ensure that public dollars are not diverted because of connections or influence to private interest. Those rules exist because they provide the only way to make sure that state agencies stay on institutional target. Stay on institutional target. Ensure the discipline that the competition of the market provides in markets. Against that backdrop, there is one part of the background paper, I think, Mr. Chairman, members, that is worth quoting from because I think it's potentially very alarming. It appears on page 6 of the background paper under the heading Possible Directed Contracts. Quote, "It is difficult to obtain documents indicating if the CPUC directed a regulated entity." Stop. Just because these regulated entities are large corporations doesn't mean that it's okay for the CPUC to direct them or direct them to do things they may not otherwise want to do. So continuing, "It is difficult to obtain documents indicating if the CPUC directed a regulated entity to enter into a contract. For the most part, contracts, evaluations of bidders, and assessments of qualifications are either confidential or heavily redacted, making it difficult for the public to determine whether the award was made in the interest of ratepayers." And this concludes on page 7, where it says, "PG&E deemed the information about the price and feasibility of the projects confidential." Harkening back to our big picture, the monies that are being spent here in the government are ratepayer money. And the government agency that is being asked for information about basic operations is a state government agency. It ought to be the case from the public interest perspective that every penny spent by a state agency or under its aegis, every policy enacted, every decision made in furtherance of state policy should be subject to oversight and review by you, Mr. Chairman, and the members of this committee and the members of the legislature as well as the public. Now, it is true, as Mr. Randolph's excellent testimony articulated, that there are a lot of policies and practices within the PUC that are designed to ensure the regularity of operations and generally as well as contracting. The problem isn't with Mr. Randolph's testimony. It wasn't that the policies and practices that he outlined weren't either good or followed. The problem is that Mr. Randolph's testimony doesn't take place in a vacuum. It must be viewed in light of what we know about the off-the-books culture and business practices that were directing the expenditure of ratepayer dollars in the CPUC, all of the information that we know about what was conducted ex parte. So the policies and practices are laudable, even assuming that they were entirely adhered to. We do know that in this agency, there was a significant amount of decision-making taking place on key matters in ways that were extra policy and extra procedure. And it is the obligation of this agency and the right of the public to figure out what happened. I'll conclude with this thought. There should not be an arm of state government in any way, shape, or form that is allowed to operate as a sort of semi-autonomous nation state with its own culture, its own policies and practices, its own constant and enduring source of money above and beyond the scrutiny of you, Mr. Chairman, and your colleagues, and the public. And in the absence of a ratepayer being able to shop for a different CPUC in a competitive marketplace, and in light of the fact that ratepayers are obligated to pay these rates in the same way that taxpayers are, it respectfully is up to this legislature, both in terms of extremely worthwhile oversight hearings like this one, Mr. Chairman, and as well in the laws that you pass, to make sure that the ratepayers' money is honored. And with that, I'll conclude my testimony, and thank you very much.
Thank you. We'll take questions from members. Mr. Quirk, and then Mr. Obernolte.
So, Mr. Bender, with regard to the $5 million for defense, had that not been a revision, had that gone straight forward, it still would it have needed a vote by the commissioners to approve the $5 million for the lawyers?
I think this question may be better directed to the PUC. I don't know all the ins and outs of what the commission delegates to staff and what it doesn't.
Sure.
I know it. I know we look at that. I wasn't personally involved in reviewing the contracts, though.
All right. Well, someone from the PUC can answer then.
Right now, there is no specific requirement by the commissioners to have a vote on any specific contract. I know that as part of their governance efforts under President Picker, they are considering whether or not to establish a requirement for votes. But right now, the responsibility for signing contracts is at the executive director level. And then we have a signature delegation to me at specified thresholds.
So, for any contract?
Correct.
So, okay. Well, I didn't understand that. Thank you.
Yes.
Mr. Obernolte.
Thank you, Mr. Chair. My first question is for DGS. Mr. Bender, since contracts for legal services are not subject to competitive biddings, how can the DGS determine if the cost of one of those contracts is reasonable?
That's a really good question. We review a lot of legal services contracts annually. Most contracts for legal services tend not to be cheap, and so we see a lot of contracts for different agencies, different legal services. We definitely took a look at the rates on this one. I think the PUC may be able to talk a little bit about the efforts that they undertook to identify different providers of legal services and to at least attempt to solicit more than one firm in terms of interest. As I understand it, the selection of firms that were actually available from the standpoint of conflicts with other clients, notably regulated utilities, was pretty limited.
Okay, thank you. I have a couple questions for the CPUC. I'm wondering if you agree with the LAO's contention that the document that you provided the legislature was not a zero-based budget.
I would agree that it did not provide that analytic framework that the LAO described as being something that they felt was crucial to a zero-based budget. What we attempted to do in the document that we prepared was to provide transparency into the way that the budget is managed, how the resources are allocated, the basis for that allocation. We did not go that next step of doing the analytical assessment of whether the resources were allocated correctly. Frankly, it's because when we looked at the way that the resources were allocated, there was very few areas where there was large numbers of resources assigned to specific responsibilities. And so we would have had to do how you do that trade-off is hard to do because we have all these priorities that are established in the code by the legislature. We did not want to inject our assessment of whether one particular area was a higher priority than the other. We would have had to do that in making that assessment of whether resources were properly allocated.
Okay, well, I'm not trying to be critical of your efforts, but I'm just wondering where the disconnect is. Is that you did not understand that to be part of a zero-based budget when you set out to create the report? Is that the reason why that information wasn't there?
What we were trying to provide was transparency. We felt that that was what had been called for in the context of the prior legislative session, was a transparency into the way that the budget was managed and how resources were allocated. So that's where we got to, and we did not want to inject our assessment of whether a particular program had value or not. So I guess we reached a different conclusion as to what the end goal was.
All right. Thank you. And while we're on the subject of transparency, I'm curious if you agree with the Center for Public Interest Law that the contracting process should be more transparent.
Are you speaking with respect to the CPUC's state contracts or with the oversight of the utility contracts?
Well, in particular, the issues that they identified with, for example, identification of bidders.
I think that's more in reference to the contracts that we oversee with the utilities. And I do agree that the process can be more transparent. There are a number of conditions in the procurement contracts, especially the larger ones, that stay confidential for up till 3 years after a project goes online. The reason for that, the stated reason for that, is it's market sensitive information, and if that's revealed at a time when, as the utility's still out in the market purchasing resources, other parties will know what they paid and will have an insight into that. And that's a valid concern. However, local governments who run utilities play under a different set of rules, and they do not seem to have a problem if the terms of the contract are revealed shortly after approval, with those contracts being higher than what the utility contracts are. I guess I'm one of the lucky ones where I actually know what the prices of our contracts are and know what of the utilities contracts are versus, say, LAWPs versus a state that has a different process. And I don't see a big difference in the price. So I don't see a whole lot of public harm in looking at how to reveal some of the terms of the contract much sooner in the process than we do. That would come to the question of, well, why don't we? Part is statute, though to point it entirely to statute I think would be a cop-out on our part, because part of it is our rules. We have, over the last few years, had staff proposals that have proposed changing some of these rules to make these pricing terms more or public sooner. Unfortunately, those staff proposals have been criticized from all sides. And you get to a point where you've got, okay, we've got 8 things we need to get done this year. Where's our priority fight right now? And that just hasn't moved up to that point that was there. A statutory change would, to be blunt, could actually help a lot. I would also caution to be careful on a statutory change, because if you do it wrong, then we are revealing market-sensitive information. And it should be pointed out that there's been, over the last 4 years, there have been 2 different bills moving through the legislature to loosen our confidentiality rules, and neither one of those made it to the governor.
Okay, well,
Yeah.
that's a good answer. I think what you're hearing, though, is a desire of all the parties' parts to make the process more transparent. So to the extent that we can, along with you, identify those statutory impediments and eliminate them, I think that we'd like to.
I mean, speaking for me and a lot of folks at the Commission, we would be happy to once again try to partner with the legislature to come up with the necessary changes.
Okay, well, I mean, in particular, I expected you to kind of defend why it shouldn't be more transparent. And if we're all agreeing it should be more transparent, then let's make it more transparent.